Let's now bring you a report on the existing systems and distance arbitration can go as an alternative to litigation in the delivery of justice.
It's the gathering of lawyers, arbitrators, and other invited guests at the 16th Annual Crusade for Justice lecture. The theme for this year lecture is Good Governance and an Effective Justice Delivery System as critical requirement for a stable polity.
A survey that was carried out in 2018 by Queen Mary College in London actually showed as follows. When they asked 100 respondents that what is their preferred mode of settlement, you won't believe it, 97% of them said they preferred arbitration, international arbitration, as their mode of resolving disputes. And what were the reasons? The first is they find enforceability of awards extremely easy. The second is those parties prefer arbitration because they have the opportunity of avoiding some specific legal systems and some national courts. I wonder which courts those are and which legal systems they avoid. I'm quite sure your guess is as good as mine. 2, 3, they find it to be very flexible. And lastly, the ability of the parties to select their own arbitrators. So those are the reasons why most people these days are going for arbitration as opposed to being in courts for years trying to resolve a dispute.
Lecture on the subject of arbitration, an alternative for litigation in the delivery of justice, was discussed.
Also possible for you to have good governance outside the office.
Good governance and democracy in Nigeria's political setting was topical in view of the 2019 general elections.
For you to have good governance, the government must be open and accessible to the people as to enable them participate in governance. Where the people are shut out from the government, there is no way they can understand what is going on. And if it is shrouded in secrecy, it is certain that you cannot guarantee any good coming out from that government.
A panel of discussants also shared their thoughts on other issues as questions were asked by invited guests.
The challenges we've had over the years by the protracted nature of litigations in Nigeria, suggest that we should look for alternative ways of dealing with disputes, and that is what arbitration has provided. Even though arbitration on its own is beginning to have some hiccups, but it is nothing to be compared with the tiring and protracted litigation struggles in Nigeria. So I believe these are the things that weighed on the minds of those that sat together to discuss this, and that is why we came up with issues that border on good governance and arbitration.
If the court system complements arbitration, the likelihood is that more cases will be dispensed speedily. And if cases are dispensed speedily, then the foreign investors are encouraged to come, believing that if they have any disputes with us in Nigeria, or if they have any dispute involving a Nigerian company, and they choose Nigeria as the forum or venue for arbitration, they are sure that they would obtain justice at a speed that is in line with the speed of justice in their own country.
And from there, let's check out some of the top trending stories we tracked at the court.
The Supreme Court has overturned the decision of the Court of Appeal, Port Harcourt Division, which permitted the conduct of congresses by the All Progressives Congress in Rivers State. The order of the appeal court issued on June the 21st, 2018 against the ruling of a Rivers State High Court was voided by the Apex Court on the grounds that the appellate court acted in bad faith. Delivering judgment in an appeal filed by one Abdullahi Umar, Justice Santos Nweze held that the Court of Appeal ought not to have vacated the injunctive order issued against the APC by the Rivers State High Court on the conduct of the congresses. The Federal High Court sitting in Lagos has granted 50 million naira bail to the former governor of Ekiti State, Ayodele Fayose. The presiding judge, Mojisola Olateregun, admitted Mr. Fayose to bail with two sureties who must issue a 50 million naira bond in a reputable bank and possess 3-year tax clearance. She also directed that the former governor deposit his international passport with the court. Mr. Fayoshehu was arraigned on an 11-count charge bordering on an alleged laundering of 4.7 billion naira, has pleaded not guilty to all the counts. A federal high court sitting in Jalingo, Taraba State, has granted an application by the EFCC to summon the former acting governor of Taraba State, Sani Danladi. Mr. Danladi, the governorship candidate of the All Progressives Congress, is to appear before the court on December the 5th with 2 others. The 3 men, including the former Minister for Labour and Productivity, Joel Ikenya, and a former Speaker of the Taraba State House of Assembly, Marco Seni, are facing 2 counts of conspiracy and violation of financial regulations to the tune of 450 million naira from former President Goodluck Jonathan to prosecute the 2015 general election in Taraba State.
For our question of the week, we asked legal practitioners to interpret the definition of contempt of court on the occasion of the Supreme Court ruling on the appeal court's decision on Rivers State.
Well, there are 2 types of contempt of courts. There's one called in facie cry, that is in the face of the court. And there's one called ex facie cry, that is outside the court. When it is in facie cry, that means it's a contempt based on conduct within the court premises or inside the court, in the face of the court. Then the court can summarily convict you for contempt. For instance, if you interrupt proceedings unrudely, or you do anything to thwart or to impede the smooth running of the course of justice, you can be found to be guilty of contempt in the face of the court. Then there's what is called ex facie cry, that is outside the face of the court. And this one has to do with obeying the order of court.
Usually when a court gives orders and it is not obeyed, it is an outright contempt of that court. And so many courts do not take it in good taste because it renders them powerless.
A high court has given an order in respect of a group of persons or an individual. It will become contempt of court where you do not abide by the rules or the decision of the high court. It was on the basis of these certain individuals have appealed to the Court of Appeal or to the High Court as the case may be. And then the High Court has vacated such an order, or the Court of Appeal or the Supreme Court has vacated such an order. In this instance, it no longer becomes a contempt of court.
In respect of the Congress held by APC and all that, the court specifically ordered a particular party not to do it and then went ahead to do the thing. Now, what they were looking at was that, well, it will cost so much, or it will to get another Congress done, and also that it will not comply with the provisions of the Electoral Act in respect of submission of names for the positions that was vied for. So they quickly went ahead to do it, despite a specific order not to do so. But then, you now begin to look at it. Sometimes you say orders are issued, whether it is arbitrary or otherwise. An order of court is an order of court you must obey.
That's it on today's episode of the program. Please feel free to send in your comments on any of the issues we featured today. Do also remember that you can watch this episode and past episode of the program on our YouTube channel. I'm Millicent Walker. Many thanks for watching.